Rule Against Double Jeopardy. The rule against double jeopardy is a fundamental principle of criminal jurisprudence which protects a person from being prosecuted or punished more than once for the same offense. The doctrine is based on the maxim nemo debit bis vexari pro una et edem causa, which means no person should be vexed twice for the same cause. The principle ensures finality in criminal proceedings and protects individuals from repeated prosecutions arising out of the same offense. Once a person has been lawfully tried by a competent court and has either been convicted or acquitted, he cannot ordinarily be subjected to another trial for the same offense. This rule is recognized both as statutory right under criminal procedure law and as a constitutional guarantee. Legal provision. The rule against double jeopardy is embodied in Section 337 of the BNSS 2023, which is corresponding to Section 300 of the Code of Criminal Procedure 1973. Article 22 of the Constitution of India, which provides no person shall be prosecuted and punished for the same offense more than once. Object of the rule. The objectives of the rule against double jeopardy are to protect individuals from repeated prosecutions, to ensure finality of judicial decisions, to prevent abuse of criminal justice system, to safeguard personal liberty, to promote certain and fairness in criminal proceedings. Essential conditions for application of 337 of the BNSS 2023. For the protection against double jeopardy to apply, the following conditions must be satisfied. Previous trial by a competent court. The accused must have been tried by a court having lawful jurisdiction over the matter. Conviction or acquittal. The previous trial must have resulted in either conviction or acquittal. Conviction or acquittal must remain in force. The earlier conviction or acquittal must still be operative and must not have been set aside by a higher court. Same offense or same facts. The subsequent prosecution must relate either to the same offense or to another offense arising from the same facts for which a different charge could have been framed in the earlier trial. When these conditions are fulfilled, a second trial is barred. Exceptions to the rule. Section 337 of the BNSS 2023 recognizes certain exceptions. Trial for a distinct offense. Under Section 337(2), a person may be tried with the consent of the state government for a distinct offense for which a separate charge could have been framed under Section 243(1) of the BNSS 2023. Consequences not known at the time of first trial. Under Section 337(3), where an act causes consequences that were not known or had not occurred at the time of the first conviction, the accused may subsequently be tried for the offense constituted by those consequences. For example, where a victim later dies due to injuries for which the accused has previously been convicted of causing hurt, a subsequent trial for a more serious offense may be permissible. Previous court not competent. Under Section 337(4), where the first court was not competent to try the subsequent offense, a later trial for that offense is not barred. Person discharged under Section 281. Under Section 337(5) of BNSS 2023, a person discharged under Section 281 of the BNSS 2023 may be tried again for the same offense with the consent of the court that discharged him or a superior court to which that court is subordinate. Effect of Section 26 of the General Clauses Act 1897. Section 337(6) of the BNSS 2023 provides that the rule does not affect the operation of Section 26 of the General Clauses Act 1897 or Section 208 of the BNSS 2023, where a single act constitutes offences under multiple enactments. Prosecution under one law may not necessarily bar prosecution under another law, subject to statutory limitations. Explanation. The explanation to Section 337 clarifies that dismissal of a complaint or discharge of an accused does not amount to an acquittal. Therefore, such orders do not attract the protection of double jeopardy. Illustration. Suppose A is tried for theft committed as a servant and is acquitted. As long as that acquittal remains in force, A cannot again be tried for theft as a servant or for simple theft or for criminal breach of trust. If the subsequent charge arises from the same facts which formed the basis of the earlier trial, this illustration demonstrates the principle that the state cannot repeatedly prosecute a person on the same factual foundation. Constitutional protection under Article 22. Article 22 of the Constitution of India provides constitutional protection against double jeopardy. However, Article 22 applies only where there has been a prosecution, there has been punishment, and the subsequent proceeding relates to the same offense. The constitutional protection is narrower than the statutory protection under Section 337 of the BNSS 2023 because the latter applies even where there has been an acquittal. Case law. Maqbul Hussain versus State of Bombay 1953. The Supreme Court held that Article 22 applies only where there has been a prosecution before a judicial tribunal and punishment pursuant to such prosecution. S.A. Venkataraman versus Union of India 1954. The Supreme Court ruled that departmental proceedings do not amount to prosecution for the purpose of Article 22. State of Bombay versus S.L. Apte 1961. The Supreme Court held that the protection against double jeopardy applies only when the two offenses are identical in law and fact. Importance or significance. The rule against double jeopardy is significant because it protects individual liberty, it prevents harassment through repeated prosecutions, it ensures finality of criminal proceedings, it promotes public confidence in the judicial system, it upholds the rule of law and fairness in criminal justice. The doctrine serves as an important safeguard against abuse of prosecutorial power. Conclusion. The rule against double jeopardy embodied in Section 337 of the BNSS 2023 and Article 22 of the Constitution of India protects individuals from being tried or punished more than once for the same offense. It ensures fairness, finality, and certainty in criminal proceedings while safeguarding personal liberty as a cornerstone of criminal jurisprudence. The doctrine remains an essential protection against arbitrary and repeated prosecutions.